Lord Justice Zacaroli asked about the origin of the Actavis Project Apple documents. Just for your Lordship's reference, the evidence that was before the tribunal on that comes in Mr. Stewart's statement, which is in the reference supplemental bundle, tab 1, page 12, and the relevant paragraphs are paragraphs 4.1 and 4.5 and 6. And that's the evidence that is available on it. There are two more passages in the tribunal's judgment that I just wish to deal with, hopefully very briefly. The first, which we were partway through dealing with, is from 340 onwards, the passage which we say contains some of the most egregious examples of the tribunal reversing the burden of proof, and I just wanted to highlight why we say that. We look at 341 on page 461 of the bundle. We can see the tribunal saying, third line down, where price exceeds costs for no pro-competitive reason that can be discerned, then the question of whether the excess of price over cost is itself an abuse doesn't arise, whilst normal market efficiency would explain some excess. Where one has a level of price substantially exceeding cost, or in this case the cost plus value as calculated by the CMA, then absent an articulated and pro-competitive explanation, any excess will be abusive. And we say that is a classic example of a presumption of abuse on the basis of cost plus absent justification. You see a similar point.
Can I just ask you, what does the tribunal mean by pro-competitive? I mean, I raised this beforehand. I mean, it's a slightly odd phrase to use as opposed to just justification.
Justified explanation.
In my submission, what it actually means is it's case 2. And the reason I say that is if we look, for example, at 342(1 at the end of the paragraph, in our judgment, therefore, if the case is a case 3
Sorry,
case,
this is...
I'm sorry, I'm reading from 341 subparagraph 1.
342 paragraph.
I'm sorry, I'm so sorry, I've been given the wrong number. 342 subparagraph 1.
Yes.
And it says in the end, in our judgment, if the case is a case 3 case and not a case 2 case, these prices are abusive because they cannot be justified by case 1 and no competitive reason for the excess producer surplus can otherwise be articulated. And then if we look at 434, the footnote, which of course is the difference between case 3, brackets, where no justification for the producer surplus arises, and case 2, where producer surplus in excess of case 1 is capable of being justified.
So if we go all the way back to case 2, for definition, for an understanding of what's meant by pro-competitive.
Well, what's meant by what the tribunal considers to be legitimate?
Yes.
Yes.
So those are the two matters referred to in 3221.
3222. 2 is case 2. Yeah.
So pro-competitive means the matters identified here. In subparagraph 1, they refer to product differentiation is anything, any definable aspect of an offering that adds value to the buyer. Maybe it's not worth the search to try and identify what is meant by pro-competitive by reference to case 2. Doesn't necessarily identify very readily what it is you're looking for.
It identifies a very narrow category, product differentiation, although that's the classic, what it says is that the classic example is product differentiation. What it doesn't do in our submission very clearly is enable the sort of inquiry that this court directed, which is any other factors that go to the fairness.
Yeah. But also, you can legitimately say, if you're trying to sort of understand what's going on here, that because he says he talks about not being able to be justified by case 1, so case 1 is relative inefficiency among sellers, and that's a justified reason.
Yes.
So when he uses the words, or when they use the words pro-competitive explanation, they can't just mean justified, because they'd have to include case 1.
I think he means either case 1 or case 2. Those are the two scenarios in which the tribunal has...
Yeah, I follow.
considered it to be legitimate.
Yeah. But your real point is that it's too narrow.
It's too narrow, it's too theoretical, it bears no resemblance to the actual test that's set out by this court.
Yes, the only other example given is the face masks example, beyond differentiation.
Plus the one point that we say is correct, which is that the ability to supply a product that others cannot is a source of value. We do rely on that because we say that's the situation that we were able to supply full label products. But it may assist to look at 3422 as well, where, and again we say this is really quite striking, it's significant that none of the appellants advanced any explanation for the excess that was consistent with a competitive market or which justified a producer surplus through the maximisation of economic value through product differentiation. So there again we have all that reference to the terminology of case 1, case 2, case 3. We of course do not agree that that is a correct characterisation of our position at all.
Is the reference to consistent with a competitive market an indirect reference to comparables?
No, I'm going to show the court what it says in relation to comparables, but it's not dealt with in this section, it's dealt with in a very much as an afterthought in a different section. What it's saying here is we find that telling, and then this, which again is important. This is a case where there was, as we have found, dominance on the part of all holders of the Merck, Sharp and Doe MAs. There was therefore an absence of competition that provided a platform for the generation of producer surplus without any added value to the buyers. Now what that is doing in my submission is essentially simply assuming that this is pricing which is attributable to the dominant position. That is the assumption that's being made. And of course, all excessive prices would involve dominance. All excessive pricing cases would involve dominance.
Well, it's providing a platform for it. That's not quite saying. It's not quite saying it equates to that.
In my submission, what it's saying is that the reason these are unjustifiable prices is because they relate to essentially pricing in a situation of dominance. We can see similarly subparagraph 4 at the end. Subparagraph 4 is dealing with what the court earlier described as the foothills of the Matterhorn. And what it says at the end of this paragraph, the difference between the two cases is that in case 2, the producer surplus is justifiable, and in case 3, it's not. The situation before us, whatever phase is under consideration, falls within case 3, so this is essentially producer surplus in circumstances of dominance. And it follows that even if prices are falling, provided they sit above cost or cost plus in this case, they infringe the Chapter 2 prohibition. In our submission, that is simply the wrong test. What the tribunal should have done is conduct a proper factual inquiry into the factors that users and consumers in this market in fact value and what they will reasonably pay for. And the court has my submissions as to the demand side factors we say ought to have been taken into account in that exercise.
Can I hopefully just enumerate them for me? So what is it that was excluded from the CAT's consideration by its wrongful taxonomy? So,
first of all, the intrinsic value of this life-saving medication as a product, notwithstanding that it's old and off patent, it still has intrinsic value. Secondly, the fact that as canvassed before the short adjournment, this is a product which would not have been on the market at all had it not been for Auden Actavis. And we say in relation to that that the relevant counterfactual is not simply the same product available at a lower price, it's that this product wouldn't have been available at all. Your Lordship was asking me in that context, well, can't one just assume that somebody else might have bought it? The dynamic here is that the party that has the power to make inquiry as to whether, had Auden not bought it, somebody else would, is the CMA. It has the power to ask those questions. We saw the document we actually looked at was the CMA's section 26 question to Merck, Sharp and Doe. Had it wished to say, actually, somebody else clearly would have been the beneficiary of this MA had Auden not bought it, that is something that it should have used its powers to investigate. We, as the party facing this allegation, only have what the CMA chose to ask to the relevant MA. The next source of demand side value is the fact that Auden Actavis's MA was full label rather than skinny label.
Sorry, the MA was
full label rather than skin label.
for full label, yes.
And the tribunal has found as a fact that that was a relevant source of value for at least some prescribers, and that's paragraph 243, subparagraph 8, subparagraph Roman 5, subparagraph C that I showed the court earlier. And finally, we make the point that, like most pharmaceutical companies, Auden Actavis approached its pricing during the material period on a portfolio basis. And we say that that means that excessive profits made in respect of one drug may not be unfair when viewed in context. That's something the tribunal did deal with at 352 to 353, and it said portfolio pricing can't automatically justify a higher price. To be clear, we are not suggesting that portfolio pricing automatically justifies a higher price. We say that that factor, together with the others that we've identified, mean it is particularly important that both the CMA and the tribunal gave proper consideration to potential comparators in order fairly to assess the pricing which is being criticised. And we say, unfortunately, neither the CMA nor the tribunal actually did so. That does bring
What's wrong with 352, 353? It seems to be a conclusion on the facts, that no evidence had been put forward to demonstrate that there was portfolio pricing. And as you know, we've had this in a number of other cases. I think it's probably started in NAP, and it goes back a long way. But it's a question of fact. We certainly haven't ruled out portfolio pricing. It's an important consideration. But the question is, was it on the facts? And they say, had a detailed justification of a price based on portfolio pricing been advanced, we would have considered it. But no such justification was advanced.
Yes. The difficulty we have with this is that it's characterising our submission as being that portfolio pricing automatically justifies a higher price, which is not the submission we were making. The submission is, because of portfolio pricing as one element of the context in conjunction with the others that we highlighted, it becomes particularly important to look at comparators, and that's where we say the failing takes place, because they just didn't. And perhaps I could show the court very quickly what was said on comparators. To locate it within the judgment, we look at page 462 in the bundle.
Postscript on excessive or abusive prices.
Well, it's after that. There is a heading, postscript, excessive or abusive prices, case 2, which is subheading C. Over the page, there is then D, other points that require determination. And then under 346, the starting observation is, although they don't affect the conclusion we've expressed, a number of other points are raised before us in these appeals with which we need to dispose. So in our submission, that's really not a very auspicious start in terms of according appropriate consideration to comparators. We then have 348, and this is essentially where comparables are dismissed in a single paragraph. It mentions a number of products, notably Plenadrin, which sold at prices far higher than the focal products in this case. So that there is a finding that there were at least higher prices in that context. We don't consider such comparables to be of assistance in the present case, for the reasons we've given at length in this judgment. Prices of medicinal products in the market were not competitive prices, but were distorted for reasons that we have given. Nothing can be learned from them. And that is the end of the treatment of comparables. Now, in our submission, that is fundamentally problematic for a number of reasons. First of all, the tribunal in itself, in its own reasoning on market definition, highlighted the oddity of excluding Plenadrin from the market, and it emphasised that it contains the same active ingredients, is indicated for the treatment of the same condition, and it found that the CMA's decision contains no good basis to conclude that it was distinguishable on clinical grounds. It has found that it is a substitute for Auden Actavis' hydrocortisone tablets, and we say that makes it a very obvious comparator. Now, despite the fact that it took a different view from the CMA on market definition, it still says that nothing can be learned from Plenadrin because the prices in the market were not competitive prices. We say that is misconceived for two reasons. The first is, again, a finding the tribunal itself made at 211. Doctors were inhibited from prescribing Plenadrin on grounds of price or cost because it was too expensive. So we say on the tribunal's own findings, the very reason Plenogin was prescribed so infrequently was because Auden Actavis's same active ingredient product was cheaper. And that is self-evidently an absolutely fundamental consideration to take into account in trying to assess whether or not that same active ingredient product is or is not fairly priced. We say it makes no sense whatsoever simply to push aside and exclude a comparator that is that close, particularly on the grounds that it is too expensive.
Could they not both be unfairly priced?
Well, that is the inquiry that we say ought to have been
in the
made.
sense that your product is unfairly priced, but Plenogin is unfairly priced squared, which is why doctors don't prescribe it.
Well, my lord, I've shown the court, the tribunal's findings, that as far as it's concerned, it is not suggesting that there was any infringement in relation to Plenogin. It was at pains to say there was no unfair pricing in the sense of an infringement.
It was making no finding of infringement, which of course jurisdictionally it couldn't do.
Yes.
But, I mean, there was a lurking undertone to that statement. We can't find an infringement, and we're not saying, but we are saying it was not competitively priced.
Well, insofar as that sought to be relied on against me, in my submission, that would need quite substantially more reasoning than a lurking undertone to be a fair basis on which to disregard.
We're not making a finding, but it doesn't prevent us from saying that the price was supra-competitive.
They say it wasn't a competitive price, is what they said.
Yeah.
Now, we say it is dangerous to be excluding pricing comparators, particularly ones that have been found to be within the relevant market and a substitute, on the basis that they're not the products of a competitive market. Because by definition, in cases of excessive pricing, products that are within the market, there will be a finding of dominance. And so you are, in one fell swoop, excluding those comparators that will be closest to the product that is alleged to be unfairly priced. And that means that the undertaking that's accused of excessive pricing is deprived of the ability to rely on those most obvious comparators. And we say that can't be right as a matter of law. And that, in my submission, is the point that was then being made in paragraph 249 of the court's recent judgment in Flynn Pharma 2. Because what we get from that is one doesn't just say, it's not competitive, that's the end of the inquiry. To the extent that there is a concern to that effect, that needs to be bottomed out. One doesn't just disregard it as completely uninformative. To make a similar point about the exchange with the court about whose burden it is to do that exercise, that inquiry is about the basis of pricing of a different product, Plenogin product, by its MA holder, Shire Pharmaceuticals. We, as the party that's being accused of excessive pricing, don't have the power to obtain information about the pricing basis of Shire Pharmaceuticals pricing. The party that does have the power, the party that should have done this inquiry had they wished to exclude this comparator, is the CMA. The other pricing comparator, as the court's aware, that we advanced was Hydrocortisone. I've shown the court the evidence we rely on to indicate that it was considered as a comparator both by Auden Actavis and by other market participants. The tribunal has not addressed Hydrocortisone at all. It's recorded our submission in respect of it, but it has not addressed it in substance at all. And in our submission, that is a fundamental failure properly to consider the case advanced by Auden Actavis, and it's a serious procedural and indeed substantive irregularity.
Could you just give us the reference to where they refer to your argument on hydrocortisone?
Yes. It was at the beginning of the section 303.1. So 303, I think, is in the section where they're summarising the appellant's grounds of appeal. And subparagraph 1 within that, they record the CMA, the contention on behalf of the appellant, the CMA failed to take into account the price of comparable products, brackets notably Hydrocortisone and Plenogin. My Lords, I'm conscious of the time. Those are our submissions on the on issue 2.
Thank you very much indeed. Yes, Mr. Palmer.
Well, so I'm grateful, Mr. Mills. Now I appear with Ms. John for Intas, which acquired what's now known as Accord UK on the 9th of January 2017. Now, if the court accepts my learned friend's submissions on her ground 1, which I adopt and don't repeat, then it follows that has significance also in respect of the Intas period from the 9th of January 2017 ending on the 31st of July 2018. But my submissions proceed on the basis, as they must, therefore, that there was an abuse of dominance by Accord UK at least at some point before the Intas period began, not because that's accepted or conceded, but because otherwise there'd be very little value in my making any submissions to you at all. So before the tribunal, as before the CMA, Intas's position was first that by the 9th of January 2017, Accord UK could not be said to be dominant any longer, even if it had been dominant at an earlier stage. There's no longer any dispute before this court.
Even if the undertaking had
as
been
to
dominant.
that, yes.
Yes.
Given the level of market entry which had occurred by then and continued to occur, and the fact that those competitors were inexorably putting downward pressure on Accord's prices as it fought to retain market share in the face of competition. Secondly, that during the Intas period, Accord couldn't in any event be said to have abused its position if there was any dominance, in that it only ever decreased prices in response to market pressure, and at the same time provided substantial economic value to its customers, which was reflected in those prices, which were not unfair. And thirdly, if notwithstanding those first 2 points, there was an abuse of dominance, it was not an intentional one, and the nature of Accord's conduct was substantially mitigated by the fact that it never increased prices for hydrocortisone tablets, it only ever decreased them in response to competitive pressure, and did so on the basis that it was rapidly losing market share and facing real competition, with the result that the penalty imposed failed to have regard to the circumstances in the Intas period in particular, or reflect the mitigating circumstances, and was in any event disproportionate. So my submissions to my Lords will essentially follow that 3-tier structure in that order, beginning with the dominance issues, which in fact is issue 4 on the list of issues. I'll start with that, as does our skeleton argument. Let me start with some points on the facts, many of which will be by now familiar to my Lords, but which I'll point up. In the decision, so core bundle page 657, that's the CMA decision. Paragraph 1.4.
I think that's volume 3, isn't it?
It's volume 3. It's on the screen as well, very helpfully.
Oh, yes.
I'm old-fashioned enough to have marked up my hard bundles, so I still reach for them.
Page 657.
It's page 657, paragraph 1.4. This is the summary introduction section. It's, in effect, the introduction and summary of the decision right at the top. At 1.4, we can see the decision, and I point out, first of all, under A, the infringement is stretched from the 1st of October 2008 to 31st of July 2018, so almost a 10-year period. The Intas period concerned the tail end of that excessive pricing abuse as alleged by the CMA, and restricted to that last 18 months of that period. And that was the only infringement found in respect of the Intas period. B was the 20 meg unfair pricing abuse, which you can see terminated on the 8th of January 2017. That's the beginning of the Intas period, so it's accepted to have ended following Intas's acquisition. and C and D, respectively, 20 meg and 10 meg, concern the unlawful agreements which had finished some years earlier in 2015 and 2016, respectively. And of course, Intas had had nothing to do with that. So the focus of the Intas case was that in respect of the excessive pricing abuse for 10 meg, Accord had ceased to be dominant and couldn't be said to have engaged in any abusive conduct. For the vast bulk of the period identified by the CMA, that's the 10-year period, Accord had had a monopoly in the supply of hydrocortisone tablets. That had ceased in October 2015. I could take you conveniently to the judgment at paragraph 143, that's at page 355 of the core bundle. There's a helpful table, thank you, there, which conveniently summarises the timeline for entry from skinny labels. It doesn't there list Accord, obviously, which was the full label competitor competing with these as they entered. But you have the date the skinny label market authorisation was granted, and then the date of commencement of supply from October 2015. So by the time of the beginning of the Intas period, there were already 4 skinny competitors in the market, and a 5th, Teva, who came in the following month, February, having gained their marketing authorization a few months earlier. It was Teva, of course, who sold the business to Intas. If we go to 126 of the judgment, paragraph 126, that's page 351. 126 to 128 just conveniently summarises the Teva acquisition and then sale to Intas underneath from 129. And the reason it was sold, obviously, because it was because of a merger. So there was a pro-competitive reason for the UK business to be spun off. And it was that circumstance, paragraph 129, that Intas acquired that business from Teva. But as it was negotiating that sale, as it well knew, Teva was busy acquiring its own marketing authorization for its skinny version of the very drug it was selling as part of the business to Intas. And so we well knew, therefore, that there'd be another, a 6th competitor in the market immediately after sale, as indeed happened. And within the Intas period, going back to the table, page 143, there were 2 further entrants, making 7 and then 8 competitors within the Intas period. And the 9th, Renata, was granted a marketing authorization in the event actually entered later after the Intas period in February 2019. But that threat of entry was ever present. It was common ground that there were no effective barriers to entry. Note that the CMA expressly rejected a submission by AMCO that the orphan designation acted as a barrier to entry for supplying hydrocortisone. That appears in a number of places in the CMA's decision, including most conveniently set out at footnote 1246, which appears on page 1086. No, it doesn't. Which appears on 1246, which appears at page 986. Foot of the page, where where you have the AMCO submission recorded and then the final sentence of that paragraph, given the substitution between full and skinny with 50% switching to skinny label tablets, the orphan designation did not act as a barrier to entry for supplying hydrocortisone tablets. There's a number of other references throughout the decision, which I needn't take you to. They're all set out in footnote 6 of our skeleton argument. Further, it was found that these skinny products form part of the same relevant market. You've seen that, and it's at paragraph 256 of the judgment, page 417, subparagraph 4. A paragraph you've already seen. This was applying its hypothetical consumer test to arrive at this conclusion. Advance sought to appeal against that conclusion, and we know that was dismissed as being hopeless, in the words of the Master of the Rolls. That's at Appeal Bundle 5, at tab 57, page 1746. Paragraphs 113.
I think the
Sorry, your authorities bundle.
Authorities bundle. You said appeal bundle.
I apologise in that case. I meant to say authorities bundle. Thank you.
This is from our judgment.
It is, my lord. Yes.
In the Hydrocortisone 2.
Well, it is. It's a court composed of my lord and Lord Justice Green with the Master of the Rolls, who gave the judgment, with which both other members of the court agreed.
So which page?
And page 1746.
Yeah.
And paragraph 113 onwards through to 115. That's it. Thank you. And it's that point B at 113. And then 114 is the meat of it. 4 lines down, identifying that in the Hydrocortisone 2 judgment, the one under appeal in this case, tribunal decided that the 2 products were substitutes, as had been decided in Hydrocortisone 1, it's our judgment now, as was supported by the evidence set out in Hydrocortisone 2. And then the third point at the foot of the paragraph, just below G, as H2 found, there was a downward competitive effect on prices when the skinny label product did actually enter the market. Continue to scroll down. Para 115.3.5 of Hydrocortisone 2, the tribunal said over time, because skinny label was priced at below full label and because multiple entrants competed against each other, an inevitable downward pressure on both skinny label and full label prices manifested itself. And so the market definition point, along with the other, was judged to be hopeless.
The facts are fairly clear on there. There was multiple new entry. Prices were coming down. It took a period of time, but not an excessive period of time. The question is, did the CAT analyse that sufficiently separately or discreetly in order to come to a conclusion which was relevant to your client?
I thought that's the point that I'm going towards, but
Really?
that is very much.
In some respects, it depends on whether the CAT properly grappled with what you say is a quite discrete set of facts.
Yes.
It's the other end of the Matterhorn.
It is the other end. We're downhill skiing at this point.
The man on the Clapham one is going very fast.
Exactly so. And we say what comes out of what you see there is the word inevitable. It's elsewhere described as inexorable. It was described by the CMA as a very significant price drop, along with the loss of 50% of volumes. That's their defence, paragraph 207. I won't turn it up for your note. It's in the reference supplementary bundle at page 547. What would be helpful, I think, to turn up is...
Can I just ask you a sort of conceptual question?
Yeah.
In very, very simplistic terms, the definition of dominance is an ability to act independently on the market.
Yeah.
You say that during that period, there's no evidence. You can have a situation where, which we had in Sinvan, prior dominance with a lingering effect.
Yeah.
So this period could either be, it could be no dominance, but lingering effect of prior dominance. And then it's a question of whether or not we are actually seeing what is genuinely competitive market pricing during the slide off the Matterhorn. It doesn't automatically follow that if you establish there's no dominance, that there might not be abuse connected to what went before.
There might be effects of the abuse which went before.
Causally.
That causally, yes, there might be, but not as a function as current dominance.
Not as a function of current
continuing
dominance.
abusive dominance.
But a past dominance distorting the market.
Past dominance,
yes. Which is what we had in
abuse,
Sinvan.
which for the purpose of my submissions I assume
Yes.
that there was at least at some stage. And our case was, by the time of the Intas period, that dominance and or abuse had ceased, and that doesn't mean there weren't any effects continuing.
Yeah.
We said, to the contrary, there was clearly an effect in that the competitive pressure brought by the new market entrants was taking a while to unwind, competition being a process, not an outcome. To pick up my Lord Justice Zacaroli's point earlier, yes, by the time it did get to the foot of the Matterhorn, the structure of the market was still exactly the same as it had been by the time of the beginning of the Intas period. In fact, there was some market exit along the way as prices dropped, as perhaps again as part of the function of competition, not unexpected. It was an unwinding, and the question for Intas coming in at this stage is, well, what can we expect of this process? Where is it going to land? Is it acceptable to let that process unwind and see what the competitive price level ends up being, where the foot of the mountain actually is, the extent to which that value, there is value over and above costs plus and so forth. By the time you've got a market at the end, which the CMA accepted and indeed submitted, was competitive by the time you got to the bottom of the slope. So in those circumstances, given that there's no variation in the structure of the market and there is this process going on, our case was, well, look, our submission was, first of all, when we're dominant, principally because this is all inexorable, we're losing market share. Yes, we have a differentiated product, so we can charge a premium over the skinny label, but we're still being dragged down by that skinny label competition. Yeah. And that is contraindicative of dominance, and it's contraindicative of abuse. We're entitled to let that unwind in response to competition.
This question, you say you're entitled to let it unwind.
Yeah.
If you are dominant, ex hypothesi, and the price is unfair at 100, 90, 80, 70, 60, and to hit the competitive level you need to hit 20, 25, it's still abusive until you hit 25, albeit unwinding. Maybe very relevant to penalties. It may even be that you're not dominant at that point, but you've acquired an organisation that was dominant, and it is the effect, the abuse is still continuing. So you inherit that.
Because if you start off during the dominant period with the price of 120, when it should be 20, and at the time when you inherit the business, when you take over the business, that the price is at 100, but it should be at 20 still, then there's still abuse. The effects are still there, are they not? I mean, as my Lord says, that may have an impact on what penalties should be.
Well, I need to take this in stages, if I may. First point, we say dominance had been lost.
Understood.
And if that is right, then there can't be abuse of dominance from that point on, even if effects of previous.
But you've acquired an entity which was dominant, and this is the lingering effect of that dominance into your period when you are perhaps no longer dominant.
Yeah.
That was exactly what we had in Sinvan, when the dominance might have finished, and no one quite knew what the competitive level was. The price was coming down, and the CAT and the CMA found that it hadn't got to competitive levels where it should have done, so there was still abuse. So you could be no longer dominant, you acquire a company that was dominant, but it shot a bullet and the bullet is still travelling during your period and going through glass and window causing injury, it's still continuing even though the act of abuse or the act of dominance is, well, I mean, it's just a continuing effect of prior dominance.
Yeah, so the point you're putting to me is that could still be an abuse of the prior dominance, even if dominance doesn't continue, for which the undertaking as a whole remains liable. That point I follow, but we say not only had dominance been lost, but also the abuse was not continuing, so that's our second string.
That's a question of fact.
Point is a question of fact, provided what's directed according to the law. But the point we make about that, when I said the word entitled to wait, you can't assume that the undertaking at that point has knowledge of what the market outcome following a competitive market process is going to be. With hindsight,
It's point about intention and penalties rather than anything else, isn't it? It's the state of mind, the mens rea of the company relevant?
Well, all of these matters, I say yes, I mean, but all of these matters at least go to penalty.
Yes.
That is certainly right. And we say there was a wholesale failure to recognise that, either by the CMA or by the tribunal at any point. But equally, it is not abusive, we say, to let competition work once competition is established and the market structure has changed, to allow that process to find what the competitive pricing level is, rather than to know it in advance and impose it by reason of...
That's quite a discrete point.
That is a discrete point, yeah.
But
that would be the answer.
Even if X hypothesise there is the lingering abuse of prior dominance, it's not wrong on Intas's part, I suppose, even if it was dominant, to allow the market to find its own balance. And over the course of 12 months or so.
Yes, I mean, the 18 months is the length of the Intas period defined by the CMA.
There were 4 new entrants by the time it acquired it.
Yes.
One came in shortly after, and there were 2 or 3 more which came in over the course of the next few months.
Exactly so.
So you had an increasing degree of market entry.
Exactly right.
Which itself is reasonably indicative of an absence of barriers to entry.
Yes.
And no evident ability of power over price, because you're losing it month in, month out.
Yeah, exactly right.
Can I just explore this question of lingering effect a little bit more? There's a distinction between a dominant entity abuses its dominance until point X. Point X, it loses its dominance. Thereafter, prices remain high for a while and come down. That's the effect you'd expect to see once competition starts to work its way. There's a distinction between that period exhibiting the lingering effect of the prior abuse of dominance, and that period exhibiting the lingering abuse of a prior dominance. But is there such a thing as an infringement for abuse of dominance if the party is not a dominant?
No, there isn't.
Even if it has been, but no longer is.
The short answer is no. I mean, you have to be dominant before you can be said to abuse a dominant position. So the first point of analysis ought to be, are we witnessing here a dominant company abusing its position, as was the CMA's case, or are we witnessing here an undertaking which may have previously been dominant, but is no longer, and so cannot be said any longer to be abusing a dominant position? I think, as I understood the point that my Lord Justice Green was putting to me, is that there may have been an earlier abuse of dominance by the same undertaking, notwithstanding ignoring for present purposes the change of ownership. But that the effects of that may be continuing to be felt beyond the period of dominance. And then the question is, well, should that be laid at the door of the no longer dominant company in its new ownership, which I think was my Lord's point regarding penalty.
I think it's a penalties point.
Yes.
You're shifting around there a bit, Mr. Palmer, because if you say no, it's the same undertaking, let's just stick to it being one entity, one undertaking, forget the sales and so forth. And I think the question really from all of us is, if you were abusing a dominant position for those 5 years, and then on the 1st of January or the 9th of January 2017, you're no longer dominant, but the effect of the previous abuse of dominant position is continuing into 2017, 2018, 2019. even though you're no longer dominant, the effect of the previous abuse of dominant position is still continuing.
Yeah. So,
I mean,
so
it's my Lord's point about the bullet going through the window.
that goes to the seriousness of the conduct of the undertaking in abusing its dominance at an earlier stage.
In the first place.
In the first stage.
So in
yeah.
other words, in terms of penalty,
Yeah.
if it was one undertaking, you could take account of the fact that the abuse, the effect of the abuse continued for another 3 years.
Yeah, you could take account of that, laying it at the door of the undertaking at the time it committed the abuse of dominance, the fact that it had that ongoing effect. What we say primarily is you can't lay that at the door of an acquirer who comes in, who tries to do the right thing and let prices come down to reach their competitive level in the belief that there's a competitive market. If I'm ultimately wrong about that, there is some blame.
Lay that in the door in respect of what? I mean, 10-year period, 9 years of dominance, dominance ends, but the abuse continues for another 12 months. So 10 years of infringement, if you like. So you come in and you acquire the undertaking during the period where the dominance ends, but the abuse is continuing. So the question is, what is your liability? You've acquired a company that presumably can be penalised for 9 years of dominance and 1 year of lingering abuse. Isn't that really a point about penalties rather than infringement?
I would resist the characterisation of that of continuing abuse. I would recategorise it as continuing effects of an earlier abuse.
All right.
Because there cannot be an abuse.
Yeah, the price is still at a level which is unfair. It continues to unfair until it hits that point there. It may be lingering effects, but the price which is being charged is still supra-competitive and too high. So
on the assumption that it is, we say it wasn't, and we have arguments about that.
You're quite understood.
But if it were to be found that the price during that period continued to be unfair, then that is a consequence of an early abuse unwinding. It's the overhang period. The fact that you wouldn't have an overhang period at all if there wasn't a previous abuse of dominance. So you're identifying an overhang period. You're saying that is part of the effects of the original abuse of dominance. That has to be reflected, no doubt, in the penalty which is applied in respect of that earlier abuse of dominance. It should not, we say, be characterised or reflected in a continuing penalty for the action of the...
Absolutely. I think we understand that this could be categorised as a serious penalty issue.
Yeah.
We're trying to get our heads around how it is to be analysed in terms of both dominance and abuse. I suspect my analogy of a gun is wrong. It's more like I run you over and I cause you serious personal injury, and that injury then becomes more and more serious. It evolves over the next 12, 18, 24 months. That the original tortious act finished, but the effects, for which I will end up paying compensation in tort at least, are going on and may run into millions because of the way the injuries evolve.
Because it all goes back to causation, to the original tort visa and the original tort. So those effects may continue. What's wrong is to say, well, look, seize on those effects. We see those effects. We see the Matterhorn slope. We're therefore going to characterise that as an abuse of dominance during the Intas period by an Intas-owned accord. And that's where we have multiple disagreements and appealed against the CMA's decision and now the Tribunal's decision on each of the limbs of dominance, abuse and penalty, saying at some stage, we hope all of them, it's a matter for my lords, that we succeed in establishing that Intas was in a radically different position to that which had come earlier. I think I can take it.
We understand the difference. I mean,
this
is regulatory, not tortious, but the tortious analogy would say that the tort was committed at the outset and then finished, and thereafter it was the effects, the damage. It was the breach of duty occurred and then the damage continued.
We shouldn't be laid at the door of the undertaking during the Intas period, but should be no doubt taken into account.
That's the question.
I'm
sorry to hang on about this, Mr. Palmer, but just to follow that through, because we are dealing here with the fact that although it may have been the same undertaking, the entity changed. So is it your case, so far as your client is concerned, in the example we've been discussing, that you shouldn't be liable for anything at all in terms of penalty?
Yes.
But that Allergan should, as it were, continue to be liable because of the overrun of the effects of abuse into your period?
Well, that would on the assumption that there is an earlier abuse of dominance, which
on the assumption there is one.
of course I don't. It's not part of my case. It is.
If
On that assumption, and on the
then
assumption
the penalty that could lead to an increase in penalty for those who sold you the company, but not on you.
well, theoretically, although not in the fact, I know that there is not in the fact of this case where the complaint is it's already too high.
Well, I'm just trying to get the sort of
Yeah. But if one were to divorce it from the facts of this case and say, well, where does blame lie? Then it lies with the tortfeasor, we would say, effectively.
But you will then have been the beneficiary of the supra-competitive profits during the coming off the Matterhorn period.
Yes, that is true, although that would have been reflected in the purchase price, and so ultimately that would go back to the vendor and to the original tortfeasor as well. So if there was some expected level of profits being obtained,
I'm not certain. When you purchase the company, you presumably pay some sort of PE ratio based upon existing profits, not necessarily assuming that they're going to go sliding down to a tenth of where they were.
Well, they were sliding down rapidly, and the tide had turned because of the market entry. And it was absolutely, we had witness evidence about this, which wasn't cross-examined. It was absolutely expectation that it would continue downwards, and there was no illusion that or intent to maintain those high prices, let alone any ability to do so.
Yeah. Okay.
I was just going to show you, I mean, we've been talking about it, but I might as well turn it up now. Figure 4.1 of the CMA's decision, which is in the core bundle at page 947.
What's the page of the decision?
947. Oh, the internal page number is 299.
Thank you.
right.
So there you have the, we've got a number of graphs, but that's the entire infringement period and beyond. You've got the narrow 18-month period. I don't know how your eyes are, but on assumption they're no better than mine. And a useful place to look at is the key, the 10 meg competitors price, which is the dotted red hashes in the key at the bottom, is round about where the Intas period is. It begins just before that red line dot, just before February 17, and it ends obviously just after the word, or just in the middle of the word price or thereabouts. So that is the period you can see, and it's a useful graph not only for the shape of the Matterhorn as a whole, but also because it maps onto it the shift in volumes. And you can see from the grey bars, the dark grey bars of the Auden activists' volumes, the lighter grey is the competitors' volumes. So you can see that shift away at the very same time as the price is dropping, and it's a vivid illustration of
So you were trying to maintain the differential, but volume was disappearing very rapidly.
Volume was disappearing, and you can see there is a premium. The red line obviously being our price, the hash line being an average of the competitors' prices, and the extent of the premium varies over time and begins to narrow as you get on, as you'd expect. There's a lot of reference in my own friend submissions to the percentage change or the percentage uplift from the skinny price to the increasing over time. That's purely a function, of course, of the lower price dropping down. The more you bring the prices down, the greater the percentage margin is going to be. So I urge you to be cautious of those sorts of statistics. But you can see a helpful illustration of what was happening there. And so these were indeed significant drops. It drops 72% from the peak of £72 to £20 at the end of infringement. But within the Intas period alone, it's a 63% drop from £54 to £20 within that relatively narrow period of time. And there was a finding by the tribunal, not just in the passage that I referred you to, which was cited and repeated by the Court of Appeal in H2, but also in the judgment in this case at paragraph 64.6.1, which is at page 33. Internal 326, sorry, 326 of the core bundle. This is the culmination of a discussion of the drug tariff and the position of others. You can see at 661, the drug tariff acts as no real constraint at all. Rather, it is competition in the market that acts as the constraint. So that was what was recognised. And last couple of points on this as a factual background to all of the topics. Professor Valetti, the CMA's witness, also expert witness, accepted that Accord UK was unable to resist. If we go to the reference supplementary bundle at page 1611, 1611.
Unable to resist what? Competitor pricing?
The decrease in Accord's own pricing in response
because of competitive
because of the effect of competition, yeah. So I just want to show you exactly what he did say. So it's in the reference supplementary bundle. That's the, not the core supplementary bundle, but no, the number 11 there, updated, that's the reference supplementary bundle, page 1611. You can see on that page, it's my cross-examination of Professor Valetti at line 10, putting to Accord UK was powerless, was my word, to resist those price reductions. It couldn't simply freeze its prices or increase them by this stage. And he took issue with the word powerless. When there was a bit of a to and fro about that. Over the page at 1612, line 9, I again put it, I said, I didn't put it that way, Professor, please concentrate on the question. I said they were powerless to resist those price reductions. And what he said was incredibly high profits at the beginning, very high margin profits, excessive returns. Those returns were coming down because of those constraints. They could not keep the same level of profits because I said earlier, automatically if you start from £72, you're going down to £2, nothing changes at your cost level, obviously the margins are going down. The fact they're going down, he said, doesn't tell me anything whether or not they're exercising market power. So they had to do some changes. Powerless, again, is a word he still doesn't accept. Maybe we disagree on the term, but they had to do this to obviously reduce their profits, their prices. They had to, I agree that. They had to because of all the combination, maybe of the regulatory mechanism, etc., etc. So the etc., etc. does appear to include competition. That tells me nothing about their own margins, relative strength. The President intervenes and said, language is a difficult thing. If we substituted unable to resist for powerless, would you have less difficulty? Unable to resist, I mean they're not able to keep the price at the same £72. Yes, absolutely, I agree with that. Thank you, very helpful.
But just thinking that the labels are always difficult, but the facts are the price came down dramatically over the course of 12 plus months to a level in which the price was more or less converging with that of the new generic entrants. And that of itself doesn't indicate, in the loose terms, power over price.
No.
It's power responding to other prices.
Yeah.
And whether you call it powerless or whatever, but the facts speak for themselves.
Yes. Well, I hope so.
The question is now how we analyse that.
Yes.
And whether the CAT properly addressed itself to those particular issues.
To which I'm obviously going to come.
Yes.
And that accompanied not only those prices, but also dropping, obviously, from the 100% pre-entry to 40 to 50% by the time of the Intas period. You have that in the judgment at paragraph 289. That's core bundle 439. Whereas as the court will recall, this is where the tribunal breaks in response to my submission that it needed to analyse this on a phased basis, which is accepted. it did this, provided this table for the Intas phase at 289, and you can see that as at January 2017, in period 109, as the tribunal call it, the percent by volume market share was 52.58. By revenue is obviously higher, I'll come back to that. At the top of the next page, going on 6 months to period 127, it's 50.1%, and it's down on value. And then at the end of the final period, you can see it's dropped to 40.5%. That's further down that page. There it is, that's 40.5%, and the value at 63.2%. And the reason that these volumes were dropping is because by this time, two of the largest chains, that's Tesco and Day Lewis, had switched entirely or almost entirely to Skinny, and 97% of independent pharmacies, who together made up 27% of the entire market, had switched. That's, if you'll notice, at the decision, paragraph 4.122, which is in the core bundle at page 988. And also a number of NHS tenders. Might just turn that up. That is in the core bundle at page 991. Paragraph 4.128, which refers to hospital purchasing. But this was that full and Skinny hydrozone tablets were treated as the same generic medicine. It's confirmed by the fact the NHS didn't distinguish between them in its hospital tenders in England, Scotland and Wales. That's 3 separate tenders there, which included hydrocortisone tablets amongst a range of other drugs. Indeed, these tenders were awarded to suppliers of Skinny tablets, which is consistent with full and Skinny labelled tablets being considered as interchangeable. And you've got footnote 1260 there at the foot of the page, setting out those 3 tenders and their results. In England, Actavis lost on price to Amco and to Bristol for 10 and 20. Scotland lost on price to Teva for 10 meg, awarded the supply of 20 meg, and in Wales lost the supply of both to Teva. So I'll come back to this, but what was clearly happening was at a high level, at central level, these decisions being made on a bioequivalence level. There's no material difference between full and Skinny. It's the same product for the same indication, and that they are interchangeable. You've got 97% of independent pharmacies approaching this on the same basis. You've got 2 of the largest chains doing so as well. And then you've got 8 out of 10 of the largest chains who at this point have not yet switched, but there is nothing to prevent them from switching at any point. Nor is there anything to prevent any of our prevent us from competing to win Skinny customers back. But neither of those 2 things are going to happen: retain existing customers or win back former customers, unless we're competing on price. And that is what is driving. That's the very reason why there is this competitive constraint, why the presence of these Skinny labels in the market is driving our price down, as the tribunal clearly accepted and found, in a market in which these 2 products are fully interchangeable. So that's some of the background. I want to move to the dominance theme now, our Intas ground 1, or issue 4. Now, the assessment by the tribunal in its judgment of dominance begins in the judgment at page 1026 of the core bundle. Sorry, I should say, misspoke. The CMA's decision begins at page 1026 of the core bundle. and it runs through to page 1069, if you'll note. Now, the summary of its approach is at page 1027, next page, paragraph 4.230. And you can see its approach is first to look at market shares. That's at A, both pre and post entry. Secondly, at B, to look at pricing behaviour and financial performance. Thirdly, over the page at C, to look at market context, as it terms it. And that includes, at Roman 1 through to 3, three factors. The first is the unlawful agreements. The second is the orphan designation granted to Plenodren, which created a barrier to expansion, not entry, but expansion, and provided Auden activists with an assured customer base for 10 meg hydrocortisone tablets, and thereby preserved its ability to behave to an appreciable extent independently. And thirdly, the absence of countervailing buyer power. Now, none of those three factors were said to be conclusive in their own right. An overall assessment was made by the CMA, and that was in respect of the whole infringement period. So there were three main criticisms which we levelled at that approach, the first two of which were accepted by the tribunal. The first was that it needed, as the CMA should have, broken down the infringement period to consider whether there was dominance and abuse, and if so, penalty, on a phased basis, if it was going to hold Intas responsible for this abuse of dominance that was identified. It needed to respond to Intas's case, which was by January 2017, it had ceased to be dominant and had ceased to abuse, and it had not done that.
So both of those factors in C little 1 and 2 have changed as from 2017. Well, 3 is probably just a neutral factor which remains constant throughout.
It's absence of a negative, yeah. One had long since ceased by the time we get to 2017, and 2015 and 16 respectively for the two different drugs, two different size, 10 meg and 20 meg. The orphan designation granted to Plenodren remained in the CMA's decision an absolutely critical part of its reasoning, and the identification of what it called an assured customer base, later described in its defence as captive customers, and that was these 8 out of 10 large chains.
But you say that changed?
No, not during the Intas period. Those 8 out of 10 stayed with Accord UK. 2 had gone over to Skinnies, that's Day Lewis and Tesco. And as I say, almost all of the independent sector, which was a quarter of the market overall, had gone over to Skinnies. But the CMA's case was that the remainder of the market, 50% which hadn't switched, formed an assured customer base and were captive. That was its argument. And that's, I'm going to show you, featured in its decision. So anyway, that was the first point, is you say, well, you need to break this down. And if I can just give you the references, I'll turn it up. It's in the supplementary bundle, reference supplementary bundle, page 916. And on that, look like, I think it's just further down the page, yes, further down the page, 3 key respects in which the CMA failed to discharge its burden of proof, and then it was the first one was failure to assess developments by and during the Intas period. So this was our opening skeleton argument, and it ran from there through to paragraph 28, and we annexed at page 963 a list of all the areas in which the decision had relied on the pre-Intas period matters for its dominance finding, which we say was illegitimate in respect of the Intas period. And at 967, the same for the penalty assessment, where we say there hadn't been sufficient differentiation of the Intas period. Now that point was upheld by the tribunal at, I'll give you the references, need to turn that up, we've also seen it, paragraphs 178 to 179 and 264 to 266 of the judgment. But that is what caused the tribunal to undertake its own phased assessment of dominance. Note that it recognised that that phased approach was also relevant to penalty, and I'll return to that later, obviously. The second initial criticism we made of the CMA's position was also accepted by the tribunal. That is in the approach that the tribunal, that the CMA should take in regard to absolute levels of accords prices. The tribunal agreed that particular care needed to be taken in approaching accords prices as a factor in a dominance analysis, given the potential risk of a bootstraps argument in an excessive pricing case. What the tribunal said in its judgment at 268, that's page 423, the core bundle, 268 to 269, is it's more rigorous to consider whether and why it is that an undertaking can price without constraint, rather than just looking at absolute price levels. Now, the last sort of initial point that we made is a crucial one, and that is the question of whether Accord UK had an assured customer base during the Intas period. Now, there's a dispute, it seems, between us and the CMA as to what the tribunal made of the argument. Suffice to say, at the moment, and I will show you this in a moment, there was a sustained and lengthy attack on that conclusion by the CMA that Intas could treat that customer base as assured by the time of the Intas period. There was lengthy cross-examination on both sides, both of Professor Villetti and indeed of our expert witness, Simon Bishop. There were lengthy submissions running into hundreds of pages on both sides. You will not find a discussion of that evidence in the judgment. It is completely absent. It now appears that there is a dispute between us as to whether or not the tribunal actually upheld the CMA's case that there was an assured customer base. I want to show you that there wasn't such a finding. Indeed, what we said in our initial skirting argument, the foresight of the CMA is rather surprising.
It wasn't such a... You're going to show us that there wasn't which finding? There wasn't a finding of an assured customer base?
Yeah.
They didn't make that finding?
They did not make that finding. Indeed, the reverse, implicitly, in finding that the skinny and full label products fell within the same market.
But I'm sorry, so this is relevant because otherwise Mr. Holmes is going to say this is a fact finding and therefore we shouldn't be interfering.
Yeah, but he would say that. We say no such fact was found.
If it was found, but you say it wasn't found.
Wasn't
or
found.
It's not sufficiently clear.
And Mr. Holmes says it was.
It was. Okay.
We have two responses to that. One is it simply wasn't, implicitly at least.
Yes.
Secondly, if it was, it would have to be very implicitly. I'll show you the passages of the judgment which I know relies upon. It was found without any reference to any of the submissions made on either side, despite the fact, I'll give you the headline figures now, of our written closing arguments following evidence, all that evidence from both experts and a lot of documentary evidence, of our, I think it's 112-page closing written submissions, over 20% of it was dedicated to this issue, and it was accompanied by an annex of over 100 pages long, detailing all the detail of the documentary evidence. I'll show you where that is. I don't expect this court to to get into all that detail. I'm not going to ask you to, but you can see that that was a dispute, to which there was equally a response some weeks later, 6 weeks after the close of the trial, with the permission of the tribunal. The CMA put in a counter table, a counter schedule, seeking to respond to all of our points. And what it was a detailed analysis of the documentary evidence underlying the CMA's conclusions that in some sense these 8 supermarkets and pharmacy chains could be assured. That was a matter of hot dispute between us. And it was because this was a fundamental feature, as I'll show you in a moment as well, of the CMA's reasoning, which tipped not only into the dominance assessment, but also later into the abuse assessment as well. And so what appears to be the position, either implicitly they accepted our case on this, or they simply considered, the tribunal it is, considered that it didn't need to resolve this in one way or the other at all for the purposes of its dominance assessment, which may well be the conclusion that the court comes to, having looked at what they do. They simply don't address it at all. They must have thought they could reach their dominance assessment conclusions without regard to this at all. And if that is right, we say that's a further error in their dominance assessment. They concentrate on market shares and what they call a relative disadvantage in respect of not having a full label and only having a skinny label, which is a long way short of finding an assured customer base who, for some reason, despite being exact same regulatory position as the independent pharmacies, exact same regulatory position as Tesco and Day Lewis, the proposition was somehow could be relied upon, whatever the price, to stay with Accord UK because they were captive. We said that made absolutely no sense on any level and wasn't supported by the documentary evidence. So let me just show you some of the references to support what I've been saying to you. The first reference I'm going to give you is to the CMA decision at Core Bundle 1029. So this is following on from the summary of the dominance findings, which I showed you earlier. They first deal with the pre-entry period. We could ignore as no skinny products then. If we go to 1033, we get to the post-entry period. And the conclusion comes first, in that first paragraph on the page. Now, activists retained its dominant position throughout the post-entry period. 4.244, the next paragraph, explains why the loss of market share and decline in pricing, which we were looking at earlier, was not determinative, and looking at its ability to charge a premium. And then this at 4.245, an explanation as to how it could charge this premium. Actavis was able to retain its position of economic strength despite the emergence of competition due to the barrier to expansion created by orphan designation. Actavis had an assured base of customers that had no choice but to purchase Auden Actavis's tablets that allowed Actavis to profitably charge a significant premium above its competitors' pricing. And there's a reference back to an earlier section. If you'll note, it's easy, the paragraph number is 3.280, which is at page 782. I won't go to that yet, I will go back to it later. This point was developed under the heading of market context from page 1052 onwards. The foot of 1052. From paragraph 4.288. And go on to the rest of the paragraph. You can see at the end of that same paragraph on the next page. Keep going down, please. Thank you. CMA has concluded the orphan designation was a key factor contributing to disability because it formed a barrier to expansion and provided Actavis with an assured customer base. And then at 4291, further down the page, you can see there the regulatory circumstance of the orphan designation meant a significant proportion of the market had no choice but to purchase Auden Actavis tablets and were not able to switch. Again, a reference back to which will come.
But just as you're going through this, you're emphasising a regulatory intervention, which means there is, quote, no choice.
Yeah.
That's the point which you are, and you're,
Which we challenged.
yes.
The suggestion was that while 50% of the market could switch,
Yeah.
50% of the market perceived there to be a regulatory risk attached to dispensing skinny label tablets to adults.
Well, is it a perception or is it? I'm just reading the decision. I haven't read anything which you cited to us as referring to a perception as opposed to the existence.
I'll show you. Yeah, I'll show you that in due course. I'll show you that there was in fact no regulatory risk, as shown by the fact that MHRA,
But was there any
the regulator,
was there any regulation which prevented it?
No, none at all. The regulation, the orphan designation regulation, had limited the ability of producers, manufacturers of pharmaceuticals to market them for, in this case, adults rather than children. That was the prohibition on the marketing. But anyone could look at them and say, oh, these are bioequivalent, these are absolutely identical in clinical terms, and they're a straight swap, as seen, for example, in the NHS tenders, as seen, as we'll see, by what the regulator, the MHRA, said, as unanimous medical opinion of those that the CMA
So assuming
inquired
that's
of.
true, there's a difference between a restriction on marketing and a restriction or an absence of restriction on prescribing or dispensing. Is that the point?
Totally different. So you can market it.
Is that the point?
That is the point.
The regulation
Yeah.
applies at the marketing level, and it's been, ever since I started at the bar, I've been doing cases about the difference between marketing restrictions and dispensing and restrictions.
Completely different.
Yeah.
And there is guidance on dispensing what is known off-label,
Yes.
but that is all aimed
Yeah.
at the traditional scenario in which a pharmacist or a doctor might be tempted to prescribe off-label, is because they think a particular drug will help a patient for a condition for which that drug has never been indicated.
Yes.
But that's not the position here. It's not that the drug has never been indicated, or for that to treat that condition. It's just that the marketing authorization on the label.
Yes.
This is why we call them full label and skinny label. The label is the only difference, which says, well, this should be marketed for adults. This should be marketed for. So strictly, that is off label, but not substantively. So if you're going to prescribe or dispense a drug to a patient for which that drug has never been indicated or authorised, the marketing authority, that needs a clinician to take responsibility for that. Whether the doctor,
I don't know if it's changed, but the Medicines Act used to impose a restriction on marketing, but it was very plain that GPs had prescribing freedom.
Right.
It was their discretion as to what they prescribed, and if they saw that a generic or something else was going to work, they were entitled to do that. There was no offence committed.
well, that's absolutely right, and it's all set out in the judgment and explained.
Are we to assume that all pharmacies knew that what was in the box was exactly the same?
Yeah, well, they would. No, the evidence was that they would know that it was clinically identical. Now, to what extent they concentrated on that fact and the difference between off-label dispensing in this scenario as opposed to the usual scenario, it is another matter.
Well,
Our essential
scenario, especially with the small counts.
I'm sorry, Mum.
The usual scenario, especially with the small pharmacy, speaking from personal experience, they just prescribe whatever they've got. You get a prescriptive doctor that is general, not generic, but general.
Yes.
And the pharmacy just prescribe,
They dispense rather
not, but they dispense whatever they've got in at the time.
which will reflect what they stock with and what they order in.
Precisely.
And so they can make a judgment.
It's
So
chemically
at some point they're
bioequivalent.
making a judgment
They
of
are.
what they prescribe, but what they purchase.
So
But the doctors normally wouldn't be saying, well, you must dispense X.
not normally. No, they write again. This is all in the.
Doctors know there's X, Y, and Z.
This is all in the CMA's decision and considered by the tribunal. So I'm speaking on that basis. But yes, that they found that most doctors would generally write what was called an open prescription.
But coming back to the point, that your point is that the decision says there is a regulatory obstacle. You say that insofar as there was any regulatory obstacle, it operated at the marketing and promotional level, not at the dispensing or prescribing level. and therefore, given the way the pharmacists and GPs work, they're generally reasonably aware of bioequivalent chemistry.
Yes, which is exactly why 50% of the market had switched. Yeah. Some of a good number of the remaining 50%, those who had thought of it, indeed the evidence was some of them hadn't thought about it at all, they just took what their wholesaler sent them. But others who made a decision on this perceived that there was a regulatory risk in doing this.
No, understood.
But that evidence, again, it varied from dispatch. I don't want to get into the detail of the evidence, but some of it...
But the reason I started it was because I was reading the decision and I didn't read the paragraphs you'd cited to us in terms of risk as opposed to the existence of some regulatory obstacle.
I'll show you how it boils down to risk and perception of risk in due course. But the point is, of course, early on at the first stage of market entry, so 2015, 2016, which is where much of the evidence relied upon from the CMA stemmed from. This is a new thing, there might not be familiarity, there may well be pharmacists who express some reluctance to go first on this. But by the time, our case, by the time of the Intas period, 2 years in after market entry, when 50% of the market has shifted, there's been no adverse regulatory action. Indeed, the MHRA, if you ask them, would say, no, it's fine. They were asked to issue a circular about it. They said, no, because we only issue circulars when there's a problem, not when there isn't a problem. But at any point, any pharmacist who had previously said, oh, I'm a bit worried about the regulatory, could reevaluate that and could have another look at it. And that is precisely why, to retain those customers, we're forced to drop our prices. If there's no reason, if they're that assured, why are we dropping our prices at all? We're keeping them on board, we're maintaining the premium roughly where it is. Obviously we want to retain those customers, but the suggestion that they are captive or assured, and at no point could their evaluation of any perceived regulatory risk, where there is none, in fact, as the CMA found and the tribunal found, ever be re-evaluated. Our case was that was just a nonsense. Now, it was made at length, and I've given you a flavour of it, but you will find nowhere in the judgment where that is resolved or any view expressed.
We now understand the nature of the dispute between you and the CMA.
Yeah.
We're looking at the way the CMA describes the issue in the decision.
Yes.
And then we're going to come to the judgment to see how they do or don't address it.
We're going to do exactly that. Yes, thank you, Lord. So it's going back to the references from the judgment. If I could take it, I think we're on 4.292.
Yeah.
Yes, and you can see at the bottom of that page, footnote 1460. Yeah. Again, we had submitted to the CMA, that is, that the position was precarious. So had the two largest customers, that's Boots and Lloyd's, switched, well then our share would have fallen from 50% to 13%. The answer to that is, well, they didn't. But again, we said that's why we were having to compete to retain business. Over the page, 4.293 to 4, again, emphasising 5 lines down on 293, the no choice, de facto incontestable, assured customer base. At 4294, the assured customer base activists enjoy the result of regulatory circumstance effectively provided a floor. So it was always assured of that 50%. So it was always able to retain that. Again, repeated references to no choice. Now, also page 1055, the next page, paragraph 4299 at the foot of the page. This is the response to our, if we just go up a little bit, you can see the heading there is representations on dominance in the post-entry period, and it's responding to our submission to the CMA, there are no effective barriers. And over the page, again, its ultimate answer to this at 4.301, it is the same, and again, it's relying on no choice and not able to switch. And 4306, the following page, again, it's the persistence of the features remaining high and stable, and 4.3.11 on page 1059. Again, starting with a reference back, I've said this a couple of times, I'll come back to that. That's where you'll find what I've told you that there is. But again, the same point in relation to the operation of the drug tariff in this section, reliance on not able to switch, no alternatives, sustained the market power. And even on countervailing...
Look at the bottom of 311. It is evident that pharmacies reached different positions on whether to dispense full or skinny. Both are reasonable positions. Once taken, do not imply an element of choice where there is only one supplier of the type of product in question.
I mean, we said this made no sense. What they're trying to say there is that if you make a choice, we will only stock full label tablets, then there's only one supplier of full label hydrocortisone tablets, and that is Accord. Right? Well, we understand that, but what's wrong with that is it assumes that you make a once and forever choice in 2015 when market entry of skinny labels begins, and you never revisit that even as 50% of the market shifts. You never think, oh, actually, we could save some money here, we could go for the cheaper product, and there doesn't appear to be any regulatory risk at all.
Well, the underlying premise is that it is reasonable to switch.
Indeed.
And if it's reasonable to switch one way, you can always use the leverage of switching back.
Yes.
Particularly when the prices are beginning to move.
Yep. Indeed, I mean, switching was well possible, and obviously, for so long as people didn't switch, Intas and Accord was able to maintain a price premium, which is why the value market shares are higher than the volume market shares. At 50% volume, if you're charging a higher price, your value market share is going to be higher. Yes. But it's no more informative than saying we're charging a premium, we've got 50% of the market. So as time goes on, obviously you have a greater share of the revenue from the market. In terms of your market power, it's reasonable to switch at any point. And unless you're bringing those prices down inexorably, as we're forced to do, you're increasing the chance of that switch happening. That's precisely why you're constrained. And just to roll off here, even in the absence of countervailing buyer power, it's the same point again, but just for your note, it's 4.344 to 345, which is on page 1066. Again, in relation to wholesalers, it's the same point again. I needn't labour it, but you can see this running right through the CMA's original analysis. And putting it at its lowest, this played no part in the tribunal's determination, tribunal judgment. At its highest, they actually concluded to the opposite in that consideration of market definition, as I'll show you as well. Now, I said I'd take you back to the earlier sections which are referred to. Now, time won't allow me to take you through them, but can I identify them and ask the court to read them in due course? It's page 752 of the bundle, core bundle.
So just give us an overview of what we're looking at here.
Yes, I'm just going to do that, exactly.
So it's parallels.
From paragraph 3.215 is section Roman 3. You can't be alone in finding the numbering very confusing of the CMA decision.
And where does it go until?
It goes until, this section goes until page 764, which is 3.245. That's section 3E, Roman 3. What it does is it describes the regulatory framework and then critically provides a section on the impact of that regulatory framework on prescribing and dispensing of skinny label tablets for off-label use. And that begins in particular from page 700 and 160 through to 764. That's the particular bit of this section I'd ask you to read. So that's paragraphs 3.235 through to 3.245. It's only 4 pages or so, but that's what sets out the views of the MHRA, the chief pharmaceutical officers for NHS England, Scotland and Wales, and the advice that was being given contemporaneously, and the reaction which the CMA sought from a professor consultant of endocrinology at Oxford University, who said it's all bioequivalent, and I'm not even aware of these label things, but it's all perfectly safe. So that's that section. Now the next section rolls straight on. That's section 3E Roman 4. That is at page 764. There's a summary paragraph at 3.247. And you can see in that summary, at the beginning there was uncertainty over how much demand, but there was expectation from the incumbent that customers would buy it. Some uncertainty was the scale of demand. Then it would have come as no, over the page, surprise to market participants that skinny label tablet suppliers would enter and go on to take sales. And then from October 2015, this is B, you can see about 6 lines down, increased competition in the market caused prices to fall. In the last 4 lines, skinny label tablets accounted for approximately 50% total market demand within 2 years of the first entry in October 2015, with off-label dispensing of skinny label tablets becoming widespread. Now, that may have taken some time to become widespread. You can't freeze the frame in 2015 and look at regulatory risk perception then and not refer then to it becoming widespread and assuming that everyone who initially made a choice to stay with full will remain. That's the whole point as to why I consider this position to be precarious. If you go to page 782, which is within this same section of the CMA's report, you can see there's a section there beginning pharmacy and wholesale purchasing and dispensing decision after skinny label entry. And that runs through to paragraph 3.294. Can I take you in particular at this stage to page 783? That is the table, if we can just move down just one more line in the table, thank you, of which pharmacies did what. And you can see from the relative volumes, Boots and Lloyd's are obviously big ones, not as big individually as the collection of independents together, a quarter of the market at the foot of that table, 271,000 packs ordered by them. This is in the period from March 2016 to November 2017, the heading tells us. So starting almost a year before the Intas period and running into it. And you can see that from the percentages, that you get very high percentages from Day Lewis, Tesco and the independents, and variable percentages from others, but including some very low ones, which include Boots, Lloyd's, Rowlands, Sainsbury's and Wells. It varies. And what the CMA made of this, underneath that table at 3.282, so we can just scroll down to the next paragraph, thank you. So despite them being bioequivalent, readily dispensed off-label by many pharmacies and sold at significantly lower prices, there were some pharmacies that determined they could not or should not dispense skinny label because of their assessment of a potential regulatory risk from dispensing off-label. So in those circumstances, only full label tablets were able to meet these pharmacies' needs, and these customers had no choice and were not able to switch. And that, of course, implicitly assumes that they're going to keep that assessment of the potential regulatory risk for all time, and had that as a need. And that is the basis upon which this assured customer base is identified. Just going over the page.
Is there the evidence of this so-called potential regulatory risk? Is it accepted it's false?
The tribunal found that it was reasonable to have this fear. It didn't
That's
engage.
Not the same thing as
no.
it being objectively correct or not.
It's objectively incorrect.
Does the decision address the nature of the risk?
Yes. Let me. I think the area would be going back to page 760. You can see it doesn't sort of try to quantify the risk. It essentially explains why there isn't one. But from 3237, it says prescribers overwhelmingly issued open prescriptions, which didn't distinguish. And then 3238, overwhelmingly majority prescriptions were open, didn't specify the condition. So pharmacies were able to dispense anything, full label or skinny label, as both were licensed. That's at the top of the next page. At 3240, contemporaneously, important word, and before skinny label tablets were launched, the regulator, the MHRA, and the chief pharmaceutical officers did not consider that off-label use of skinny tablets created any risks to patient safety that would justify taking any action to limit or prevent off-label use. 3241, the
consider that. So the relevant regulatory authorities did not consider there to be a risk.
Yeah.
They did not clarify the position. As a result, the CMA concluded there was some regulatory uncertainty which affected the purchasing decisions of some pharmacies.
So, some of these pharmacies expressed the view that there would be regulatory risk to dispensing these off-label.
But that was not the view of the MRHA or the...
Not the MHRA. It was not the view of any identifiable doctor. It was not the view
you can have, presumably, a barrier to switching caused by uncertainty.
Yeah.
That's just a fact. It either exists or it doesn't.
Of course.
The question is here, when you've got a significant level of switching, whether the absence of an objective regulatory obstacle, whether uncertainty should govern the definition of dominance.
Yeah, exactly so. And whether you can actually realistically say you're assured of a customer base over time. I can understand, the uncertainty may be highest at launch of skinny products in 2015, but they take that 3-4 years later, even when 50% of the market has shifted. And that was the focus of our attack.
So I'm just coming back to where we are. We sort of spent probably half.
So I'm just a bit worried about time. So if I can ask you to read the rest of that section.
Do you want to take us to the CAT judgment to show how it actually dealt with this? I mean, I think we've got the measure of the decision, and I'm sure that Mr. Holmes will come back to it if needs be.
Yes. Yes, I will do that. Can I? I think I've covered all those points.
I mean, your point is going to boil down to a failure properly to address a set of facts.
Yes, I mean, at its lowest, it's also a flaw in the dominance analysis substantively. I'll come to that in due course. The first thing is...
But sorry, I'm sorry to interrupt you, Mr. Palmer. I know you were finished, but just going back to that table you showed us and the paragraph afterwards, which was 3282, and the reference there to that some of the pharmacies were concerned that they had an assessment of potential regulatory risk. There was no evidence, was it, that they ever changed their position on that?
Not within this period.
Not within this period, no.
But that is a separate point. The fact that they didn't isn't knowable to accord in advance. Advance can't reasonably, we said, assume to itself this is an assured customer base because their perception of a regulatory risk is an immutable feature of these pharmacies for reasons not shared by the other half of the market. You can't count on that. That was essentially, there was no good reason to take it. They might initially have taken that view and then at some point asked the MHRA, having noticed that 50% of the market has shifted, can we do this? Yeah, of course you can do it. There's no problem at all. Oh, right. Well, yeah, there's no way. You don't want to give them a reason to make that sort of inquiry by refusing to drop your prices. What they're interested in financially is the maintenance of the difference between the price they are paying and the rate at which they're being reimbursed under the drug tariff. And if that's not changing, and then they've got less reason to investigate and to ask, and of course it's in our interests that they shouldn't look too closely at the regulatory position. We had a lot of other advantages to our product to rely upon an economic value which they were actually plenty of other reasons why they wouldn't have wanted to shift from us. But so far as this regulatory risk perception is concerned, there is just nothing to indicate that that could be treated by a court at the time or should be treated by the CMA in its decision as some kind of immutable characteristic of those pharmacies, which means they were assured and had no choice and were not able to switch.
Yeah.
So that was the point, and supported by a very detailed analysis of the internal documents from all of those. What were they thinking at the time, contemporaneously? What had the CMA relied upon? And just for your notes, immediately after that table, it's paragraph 3.283, page 784, which was the decisions analysis of each of those 8. It had one short subparagraph on each of those pharmacists in turn, going through in alphabetical order, starting with Asda and Boots and so forth, with footnotes to various documents. And our concern was that that was a very selective presentation of the underlying documents, hence the 100-page annex, which attempted to bring together all the evidence, and hence the CMA's response to that annex, which put its own spin and view on how those documents should be interpreted. So that was the scope of the dispute, and I'll just give you, before I come to what the tribunal did with all this, I'll just give you the references. I needn't turn them up, but our opening skeleton on this is at the reference supplementary bundle, page 920, paragraphs 29 to 36. Can I ask you to note paragraph 34 in particular, where we made the point that this theory was inconsistent with the market definition adopted by the CMA, putting them both in the same market. Closing submission after the evidence is at pages 1302 to 1325. So that's 23 pages, fifth of our total, accompanied by a 100-page annex, which is at 1391 through to 1489, which dealt in turn with pharmacies at 1391, wholesalers at 1435, short-line wholesalers who tended to supply independents at 1449, suppliers' own perceptions at 1463, and then the NHS purchasers, the tenders, so forth at 1482. I'm not asking you to read all that in detail, I just want to show you where it is, so you can see the scope of the dispute and the centrality of this to our case. The point that the tribunal did deal with was to accept that the market did not divide into two separate markets for full and skinny, as Advance and Sinven had argued. And you see that in the judgment at paragraph 233, page 403. That's core bundle 403. 233. This is recording the submission. So this is the Sinven and Advance appellants suggesting that there are two distinct customer groups who are cautious and less cautious, again as if that was immutable. And then at on the following page, 235 to 236, we accept interaction between full label and skinny label represents an extremely odd case of substitutability. Presence of some switching isn't necessarily sufficient to indicate products are in the same market. You need to understand why switching is occurring. In this case, despite a really quite material price differential, a significant part of the market did not switch the skinny label.
So what period of time are we looking at here? Is this pre-Intas?
This is on a market definition exercise. So it's at large without concentrating on Intas.
Well, it must be post-2011, mustn't it? Because
Yes.
that's when skinny label came in.
Yeah, 2015, yeah. And 236, what can be said is that the nature of the constraint was patchy, certainly didn't fully constrain full label prices because significant portions of the market were indifferent or prepared to forsake the additional margin afforded by skinny label products. It's not quite clear what's meant there about being indifferent or prepared to forsake the additional margin. They either saw advantages in our product or valued that to some extent and or perceived a regulatory...
Yeah, but doesn't that go... I mean, that's reflecting, isn't it, what the CMA said in the passage we just looked at in the table, which was that the large pharmacies, specifically Boots and Lloyds, took the view, I mean, rightly or wrongly, they took the view that the licensing regime in this country required them to purchase full label rather than skinny label. And they were concerned that the skinny label didn't comply with the licensing requirements. That's what it says.
That is what it says. That is what it says, but that is a long way
that's
short.
Why I asked you the question earlier about, is there any evidence that that ever changed?
Not within this period. We don't know. We don't have evidence about what happened later. But 2 points. One, I made the point we didn't know whether it would change, so couldn't treat them as assured. And secondly, it's a long way. This finding is a long way short of saying they are captive, that they are assured in that sense, because that regulatory risk and perception of it can change from 2015-16, which is when the Boots documents, for example, were taken from, by years later when half the market has changed and the regulators, if you ask them, would confirm it's fine. And then the last reference there is that at paragraph 256.4, page 417, which you've seen. That's the only other place where this is dealt with here, which is that skinny label with the hypothetical consumer would have no compunction about switching to skinny, because they'd appreciate the regulatory happenstance had nothing to do with it, essentially. It's an identical product, demand elasticity would be extremely high. It's important to understand where that comes from, this hypothetical consumer. The court will now be familiar with how that hypothetical consumer was constructed, but he has assumed, this is at page 408, to combine the salient, at paragraph 6, the salient characteristics of doctor, pharmacy and patient. And that means that they'd have a diagnosis, they'd want to treat their condition, and at 3, a level of knowledge about adrenal insufficiency and the various medicinal products commensurate with that of a doctor. And over the page, this is assumed, this is where the pharmacist comes in. Roman 4 at the top, an understanding of the difference in this case between skinny and full label offerings and the regulatory regime that has created that distinction. That is what the hypothetical individual with the knowledge of an ordinary pharmacist would have, and indeed that's precisely why all the independents voted with their feet and did in that way. So that rejection for market definition purposes of Sinvan and Advance's submission was made, but this was not dealt with beyond that in the dominance assessment at all. This removes a major plank of the CMA's reasoning, but the CMA, boldly in my submission, suggests that the tribunal clearly endorsed its findings. It has 3 main references. The first is that paragraphs 235 to 6, which I've just shown you. My submission is that they decline to accept the Sinvan Advance argument on market definition and declined to adopt the language of the assured customer base, and this played no part in the dominance assessment. Next, at page 118 of the judgment, that is 411, and this is the sub-paragraph C that we went to earlier with the interminable string of characters. It's 243.8 Roman 5 C, which is the high point of my friend's submissions on this. But this is still market definition for context. And the context of this is deciding the price which should be used for the purpose of the SNP test and rejecting Plenidrin's price, and saying in that context that C, instead of skinny label products being rendered non-substitutes, pharmacologically identical nature of these skinny label products combined with the off-label dispensing regime that we described meant that some pharmacies, generally the small pharmacies, not exclusively, regarded fully label and skinny label immediate release hydrocortisone tablets as substitutes, whereas other pharmacies, generally, not exclusively, the larger pharmacies, regarded skinny label as a different and non-substitutable product. Now, just pausing there, that might be true in 2015, but our point was you could not take that, even though those 8 remained with us as we dropped our prices inexorably, as meaning that they are captive or would never change their views. And indeed, the tribunal here does not go so far as to say that they were. It's simply explaining why they wouldn't take the price, and instead it would take, in the next paragraph, they'd take a £10 price instead.
And there's nothing here which tells you what time frame these general conclusions are being applied to.
There's no consideration at all of regulatory risk perception changing over time as the practice, as they became commonplace, widespread. That doesn't feature. And then I've dealt with that. And must be read in context of paragraph 256. I've done that, sorry. I'm just catching up my notes. I've gone slightly out of order. And the only other passage is at page 442. We can go straight to that. Paragraphs 294 to 295 are relied upon by the CMA as showing that their assured customer base theory was accepted. Now, where are we now in the decision? Now we are in the dominance section. If we just scroll up so the tribunal can locate it after 291, you can see this is under the heading of conclusions. So this is just after we've had all those lengthy tables, phase by phase, of market share. And it's immediately after that we get to conclusions. And we can see from 291, the first point on dominance is they all have we conclude that they're all dominant in all five phases, so why? There are a number of indicators that justify this conclusion, particularly one, the ability of Merck, Sharp and Dohm's MAs to raise the price substantially. Well, that was not during the Intas period, obviously, it only ever dropped. 2, in circumstances where demand did not fall away as a result of such price increases. Well, again, not in Intas, demand was falling away despite price decreases. And 3, where constraints on the holder, whether competitive or regulatory, appear to have been either minimal or non-existent. Again, not in Intas. We know that there were strong constraints, strong enough to reject the market definition points. Mm-hmm. So 292, all of these directly related to price, so we're going to be cautious of them anyway. But 293, relevant market shares clearly denoted dominance, and we regard this conclusion of dominance, I assume, as inevitable from the data we have set out. It's true that the market share fell over time, yeah, particularly in the Intas period. Phase 1, it was 100%, but it was rarely, if ever, less than 50%, whether by volume or by revenue. Well, that we say ought to be the starting point of the inquiry and not the end point. 294, it's also significant that many of these competitors, and here's what the CMA rely upon, namely those selling skinny label products, will have laboured at a competitive disadvantage when compared to the holder of the marketing authorisation. We've described the nature of that disadvantage already, but its effect will have been twofold. First, such competitors will have sold at lower volumes than if they had a full label product to sell. Secondly, to the extent there was demand, that demand responded to a significant discount in the price of skinny label products relative to full label products. Thus, even where there was competition, it was of limited effect, and that's reflected in the market shares that we've recorded. And then they therefore set out their conclusions that are dominant at all times at 296. And that's it on the dominance assessment. So all of that prior analysis I showed you, the balanced view of the CMA, which they arrived at, looking at market share, the pricing differential, but critically the market context, including this assured customer base, all of that is gone or not relied upon, not necessary to resolve one way or the other, in favour of this hyper-abbreviated assessment that basically market share tells you all you need to know. 294 to 295 does not contain an assessment or an acceptance of the CMA's case that there was an assured customer base. It conspicuously avoids that language. It doesn't suggest that any pharmacy had no choice or was not able to switch. We say rightly, that's clearly a complete fiction. And it's emphatically not, this is my friend cited in paragraph 18, not a reference to the tribunal's earlier findings of fact that there was an assured customer base, as there was none. So we say this is a heroic effort by the CMA to contend that there was a finding in their favour on this issue, but we say that is unsupportable. And if they were at all right that you could somehow read that in, then take their high point at paragraph 243.85c, that would have, in the market definition section, that would have been a wholly inadequately reasoned basis upon which to reject one of the mainstays of our case, with our 120 pages of written closing submissions and plenty of oral submissions as well. So by a sidewind. I mean, it's just not present and not considered. And so at its lowest, I say, they clearly didn't think it was relevant, and so dropped that aspect of the CMA's case and relied on market shares and the fact that if skinny holders also had a full label, they would have sold more, and that they competed by pricing beneath the level of full. That tells you nothing about this assured customer base, supposedly.
Just coming back to the inference from 291, the CATS analysis, you say, assumes continuity of market circumstances.
Yeah.
And you say, just for example, by looking at the pricing tables, you can show that, at least from 2017 onwards, there was no continuity.
No, there was
three factors:
no.
price rises, demand did not fall away, and minimal or non-existent constraint.
No.
Those may have been true for some years,
Yeah.
but they didn't continue.
And exactly so. And having accepted in principle our argument that the Intas period had to be considered separately and not lumped in, and for all the reasons that we discussed, that actually isn't done. They do set out the market shares separately, but then they treat that effectively as determinative and inevitable. Dominance follows from that. And I've got some further submissions to make about that, but the submissions will, the court will be fully familiar with the endless case law about the presumption arising from market shares, but none of that case law suggests that it's conclusive and you stop there. All of them say you've got to look further. Sometimes the language of exceptional circumstances is used depending on the market share and how great it is. Certainly by the time we're down to 40 to 50%, we're not in that territory. And we're inviting the tribunal to take an overall view of this, including the precariousness of our position, the fact that our volumes are going, the fact that our prices...
Stability of market share is always important over time.
Sorry,
Stability.
Yes.
Over time is always relevant.
Yes, and having lost 50%, because the remaining 50% were effectively 8 big customers, well, some of them bigger than others, but 8 customers, you lose one of those and your market share would go down. Don't lose them, you would have that stability. But there is a package of offers, again, comes to a package of reasons why we say that they would want to stay with us, because they order from bulk from us, we provide a free service of all kinds. You know, there were good reasons why they wanted to go with us. We had unchallenged evidence from Mr. Burt about that, which wasn't cross-examined, economic value that was offered. That, in some level, combined with a continued perception of regulatory risk, perhaps in some cases more than others, it's difficult to tell, but hence the review of all that documentary evidence, the forensic analysis of it all, led to a situation where we said we could not be taken to be dominant. And my submission to this court is that this assessment of dominance is woefully inadequate, even on the terms, with the task that it set itself, the tribunal set itself, of examining each phase individually, because significant characteristics of the Intas period vanish.
Well, having engaged on that exercise of looking at 5 different phases separately, they then collapsed it all into one conclusion for the whole period.
Yeah, that's exactly what happens.
Where does this take us? I mean, jumping right ahead, You've identified what you say is a failure to deal with this at all. Does that mean we can reach our own conclusions about market dominance, or is it because of all that evidence we haven't seen, does this have to go back? If you're right about it.
I have alternative submissions about that. The first is that you can reach your own conclusion that we were not dominant for the reasons that I've outlined to you. That on any sensible approach, when you've got those crashing prices, loss of market share, yes, an ability to retain a premium, but only on the basis that you're continuing to reduce it because you're offering something which is differentiated, but you're not assured of that remaining custom. If you're able to reach that conclusion, then the answer is that you can find that during the Intas period, Accord was not dominant. If you're not able to reach that conclusion, then it needs to be remitted. And my primary submission on that is it needs to be remitted back to the CMA because this assured customer base thesis was plainly wrong. But if you're not prepared to do that, then the further alternative is to remit it to the tribunal to have another go. You'd have to consider in that circumstance whether it's the same tribunal or a different tribunal, but you wouldn't make a judgment about that on the basis of a single issue alone. You'd see where you've got to at the end of all the issues and then see where that took you as a whole. So I won't address you further on that now, but obviously that's the order of preference, and it's very sensitive to what you find and what you don't find. Can I just show you one more thing before I move on from dominance? This prioritisation of market shares is not what the CMA was inviting the tribunal to do either, any more than we were. I can give you the references. CMA defence, paragraphs 176 through to 179, which is at reference supplementary bundle, page 5 through 8. The CMA's closing at paragraph 241, reference bundle 1212. Treated market share conventionally as a starting point, and of course wanted to say that we needed to demonstrate exceptional circumstances and all the rest. Apart from that, we said you have to look at that all as a whole, consider it in that light, not treat it as conclusive. Can I just show you our closing submissions on this subject? Again, just not dealt with at all by the tribunal. It's in the core supplementary bundle at page 235. You'll see there was a section on the weight to be attached to these market shares. When we make the submission at 37, it can be no more than the starting point, and they're not determinative. And then a review of the case law. I won't take time over it now, but 38 going down to 39, referring to the textbooks. We can scroll on to the next page. And then you'll see that, no doubt because of limitations on page lengths, the annoying habit of lengthy footnotes from page 237. And a review of all the cases on how market share, which is obviously a main plank of the CMA's case, should be dealt with. And I don't propose to go through it all now, but those submissions on this point ran through to page 243 of the bundle. And there you are. And none of this is dealt with. There's just no consideration of these points at all. And we're just told for reasons we don't understand, well, this lower market share in your Intas period is nonetheless conclusive. And there's no real consideration of whether any further inquiry from that is necessary. Notably and tellingly, the CMA therefore put in Respondent's notice seeking to buttress this. It's paragraph 5 of the Respondent's notice, the core bundle at page 67. What this does is to seek to rely on its own decision in respect of matters which form no part of the tribunal's decision. It's a foray into factual argument. More telling is my learned friend's skeleton at paragraph 71, where there's an attempt to argue that the tribunal's approach simply differed as a matter of form and not substance. A hopeless assertion in my submission, entirely ignoring the extent of the departure from the CMA's approach, not just on market definition, but the dominance analysis, the purported adoption of a phased approach, and then the concentration on market shares, which is precisely what the CMA had not done and did not contend should be done. It was seeking, in its Respondent's notice and skeleton, to resurrect its own decision in preference to the tribunal's flawed analysis. Our appeal against that decision, we say, effectively remains outstanding. So those are my submissions on dominance.
Can you just, have my help, give me a where I can find the market share set out? Because I think I've seen you talk about 40 to 50%. The CMA talk about it's always over 70%. You're obviously talking about different metrics.
Yes, I think I showed you in the tribunal's judgment. There is tables beginning from page 437 of the core bundle. Which goes right back to August 20. Oh, sorry, it's earlier. It begins earlier. I think. Sorry, I'm not giving you the right reference there. Sorry, beginning at page 428, which goes right back to October 2008. So the market shares, the last two columns. So starting at 100%, obviously, in October 2008. And so then there, and I think I showed you earlier, page 439, which is when they get to the Intas phase. And I showed you those percentages for market share. And it ended with the final periods 109 to 127.
That's the previous.
That was when you get to 40.5% volumes. And of course, the revenue market shares.
So we can look at that. Yeah.
That's not, I'm not sure, that's not Intas yet. No, that's 439 for Intas, I think we're on 438 there. Then the Intas phase begins, and if we can continue down from there,
go down a bit more.
That's the beginning of the Intas phase.
The beginning, and
then on the bottom of the following page
is the average.
It's the average periods 109 to
40.5.
It's 40.5 is the average over the whole period, yeah.
And which is the correct way of looking at it? Volume or revenue?
Well, the straightforward answer to that, my lord, is both. You shouldn't ignore either. The CMA advanced a case before the tribunal, which it did not accept, which is that revenue was more significant. In the case of differentiated markets, you look at revenue and therefore value of the market, and not just volume. You can see why that would be the guidance in most cases involving differentiated products, because otherwise how are you comparing like with like? But here you've got a situation with 50% of the market going one way, 50% of the other going the other way, with the supposed market power lying in the assuredness of that remaining 50%. Of course, if you're charging that 50% a higher price than the skinnies are charging, then your market share by revenue is going to be higher. I'm not sure that's an indication of greater market strength in the dynamics of this market. You're looking at here the threat that someone could re-evaluate the regulatory risk and take the money, simply, for example, by asking the MHRA, can we do this? In which case they'd say yes. The answer is, it's all an evidential picture that CMA's case that you should prefer and concentrate on the value was rejected. All that you have on that is paragraph 293 of the judgment, bottom of page 441. They say the relevant market shares brackets by volume and by revenue. So they look at both without preferring one over the other. I can take my abuse submissions a bit more quickly. They don't be relieved to hear, but and that's partly because I've covered some of the ground, in particular this point about the assured customer base, because that runs into the abuse arguments as well. And we had an argument, which is issue 1 on this court's list, that we were not imposing excessive or unfair prices, as the statute, and indeed the underlying treaty, refers to, directly or indirectly imposing unfair selling prices. That is what the statute says in a non-exhaustive way, but that is the abuse which Accord UK was accused of committing. That's in the decision I showed you earlier, paragraph 1.4a of the decision on page 657, which is expressly using the language of the statute, which is then repeated and set out from paragraph 5.23 and following page 1076 of the core bundle. And the short point is this: offering a price to the market which a buyer is free to accept or decline is not to impose an unfair price. A seller can only be said to be imposing a price when it's one which a buyer has no choice but to pay. Now, the CMA's
that would be true of an essential facility.
Yeah.
But if you've got a company with, say, 50% of the market, but still has power over price demonstrably, the customer may still have a choice to go to the other 50%, but for whatever reasons, it doesn't. Does that mean, on your analysis, it cannot, in principle, be an abuse because it isn't coercively imposed?
Well, the question is, where does the dominance lie? I mean, there must be it's very fact sensitive. The fact that someone has 50%, of course, doesn't mean they're dominant. They may be, in which case there'd be something else which indicates why that is, or an absence of other things which indicate why that isn't. So what is it?
Definition, if you've got 50% and the rest of the market have got 50, perhaps dispersed between 3 or 4 competitors, still dominant, they're all in the same product market. But
Indeed.
you've got a degree of, it's a degree of power over price. It isn't absolute power, is it?
But nonetheless, one of the sources of your dominance, if dominant you are, may be because some customers or significant proportion of customers are assured. For example, you cover a certain geographic area, a wider national market, whereas your competitors are more focused on lucrative local areas. They're in Manchester, Birmingham and London and have captured big parts of the market there, but aren't competing in rural Scotland. Now, in those circumstances, you may well have only 50% of the market, but you're still able to impose a price profitably, which is excessive.
What about if instead of impose, get away with? Because you've got a sufficient degree of power over price. Impose is, we understand that on one sense of it has a coercive element to it.
Yeah.
But I'm not certain in the context of it's a sufficient degree of power over price that you can impact a snip test in your favour. That doesn't suggest absolutism.
You don't need to have absolute power over the whole of the market in order to be able to exercise that market power over the segment, the part of the market which you have captured. And you may still be able to charge an unfair and excessive price. And if you can...
You might do so without imposing it. And as I understand your argument, there's an element of you're so powerful that they've got zero choice at all.
Yeah.
If you have 60% of the market or 70% of the market, 30% of the market is elsewhere, the customer can always choose to go elsewhere.
Well, not always.
That's not imposition in that sense.
But my answer to that, Lord, is
coercion.
My answer to that, my Lord, is the customer can't always choose to go elsewhere.
No, I understand that.
And if in sufficient number they can't, then that is likely the explanation as to why that undertaking is dominant.
But is that the same as imposing a price?
On those customers, yes. On your customers,
you ask us to find that imposed means.
You're assuming that imposed means there's a captive audience who cannot escape under any circumstances.
Which is exactly...
Which is an example of dominance, but it's not the full definition of dominance, is it?
No, that is not the full definition of dominance, but it is a likely scenario in which a dominant undertaking could be excessively pricing. How do they get away with it?
I suppose there's any disagreement to that proposition.
Yeah, I mean,
but if you're defining dominance and abuse around that definition and not accepting that it goes wider.
Well, classic examples of where excessive pricing can arise. One is where you are unavoidable in some sense. Another is maybe where there's primary and secondary markets where they've bought the watch and now you're going to charge them for repairs or whatever it is. You may not be dominant in the market for watches. You may be dominant in the market for repairs of that watch, whatever it is. There are circumstances in which you can get away with charging an unfair price where the customer is not in a position to up sticks and leave. That's the normal response to a customer who feels they're being treated unfairly. Now, you've got a range of scenarios, and they are fact sensitive. And in Le Patorel, for example, you had those single fixed phone line services with a market exemplifying, or said to be exemplifying, in at least in part of that market, a degree of inertia. Perhaps typically, one imagines sort of elderly people who are fixed and not interested in getting broadband or whatever, and not motivated to look around and see what alternatives there are. BT in that circumstances. Sorry,
they weren't coerced.
They weren't coerced.
They were inert. But they might not have been inert.
But if the operator, if the undertaking knows that they can impose a price which is not going to be met by a choice being exercised, then they are imposing a price. So you could have the theoretical ability to walk away, but if in practice you're not going to, then you're not imposing. Then you are imposing a price, and that is why, in this argument, the CMA's argument about this assured customer base filtered in to their argument about abuse as well, because they were saying it's because they're assured that you can charge these higher prices, and that's the only reason you're getting away with it.
Is there any authority on what's meant by imposed?
Yes, I'm going to show you some fairly recent authority. I'm going to show you two in particular.
Okay.
One is this court's decision in liothyronine, very brief reference.
Yeah.
But then there was a more developed discussion in a more recent decision of the tribunal chaired by Sir Peter Roth in the Gutmann and First Trains case. I'll show you that in a moment. But the point I do start by making is that one thing for the CMA in its decision to say, well, you imposed this price on a captive class of customers. We appeal that and we say, well, they're not captive and we didn't impose it. And the two are linked to that extent, at least on the facts of this case. Because if they're not captive and they're not assured and they can switch if they don't like the price, there is nothing stopping them from doing so.
Would you? I think you'd accept that if they in fact had no choice, they were regulatorily required to dispense full label, then there's a problem.
That would be an imposition.
I think you might accept that if they have a choice, but they perceive they don't, because they perceive there are risks in relation to dispensing skinny label, then you might still be imposing a price if you take advantage of that perception by maintaining high prices.
If it was possible to assume that no matter what you did with the
would
price,
say you didn't, because you actually dropped the price.
They were dropping the prices. Yeah. And they say, well, not fast enough, presumably is the argument. You should have gone down faster until you're imposing these prices. So the answer is we're not imposing them, because at any point they can say, we don't like this price, we are going to look again at this risk because we've noticed 50% of the market are doing this. What is the position? And so, again, this is where the supposed immutability of that view, of that assessment of risk, when in reality there is no risk, cannot be counted on. And it's not what by Intas, by Accord, and it's not what Accord was doing in dropping those prices. And so this, again, for time reasons, I'm just going to give you some references. Dr. James Burt gave evidence saying we didn't impose prices at paragraph 49 of his witness statement. That's in the reference supplementary bundle, page 39. Wasn't cross-examined. The point was most fully argued in our reply, paragraph 67 to 73. That's page 734 of the reference bundle. And our closing submissions of 114 to 116. It's page 284 of the core supplementary bundle. So we raised all this. What did the tribunal make of it? The answer is it didn't make anything of it at all. It didn't address it. And you see that in the judgment of paragraph 304. It's on page 444. A number of other grounds of appeal that we can deal with now. It suggested that the core UK's prices were not imposed on its customers, but its customers exercised choice in favour of the product because it had additional value to them. This adds nothing to the points we set out at 3032 above. Let's scroll up to that, 3032. That's the point about economic value. So there's no discussion of the submissions we made. I've given you the references for about what the nature of imposition is. I'll show you the authorities on that I've indicated. In the authorities bundle, page 2078, it's the liophyronine decision, paragraph 193.
This is Sinman.
Sinman, yes. Where the nature of the abuse is summed up by my lord in the last 5 lines. The abuse arises from an imbalance of power between the parties, which gives the dominant party the power to impose unfair terms. It's this which is accounted for as unilateral. Characterisation not negated merely because economic power is exercised through medium of contract. This is responding to an argument made by Advance that, well, they contracted with us, it was all agreed, we didn't impose it. And the answer is that you're exercising unilateral power notwithstanding the medium, because of your market power. That's the imposition of unfair terms. Wasn't discussed beyond that. But in Gutmann, it is discussed. That's at page 2171, from paragraph 83. So this is the boundary fares case. Paragraph 83, where just for some context, it was obviously fundamental to the class representatives case in that case, that in some way the operator was imposing unfair prices on consumers by not easily making available or making obscure the availability of boundary fares for those who have travel cards in London and want to travel from the edge of London rather than be charged for travelling from the middle of London. But there's a discussion of the authorities on this, and at 83, Sir Peter Roth, having gone through the authorities, noted in particular all the discussion is premised on an unfair contractual term which has been, italicised, imposed on the victim of exploitative abuse. As we've noted in both Deutsche Telekom and DSD, the customer wishing to use the service had no practical alternative to paying the impugned charge. In Meta, the court stressed that the German court's finding that consumers wished to use the Facebook social network had no alternative but to consent to the terms entitling Meta to broad access and use of their data, and the reference to the recent commission decision in music streaming and Spotify.
If the findings are as they're described here, then it's plainly correct to say they were imposed.
Yep.
If there was no choice, I think our concern is that that defines the category of unfairness too narrowly.
Yeah. Is there anything else below that citation from the Commission?
Not very much of interest there, apart from recognition that the imposition could be de facto.
Can we just drop down the page just to see the rest of the paragraph? Yeah, okay, we'll move on then.
What there is, what I was just going to show you briefly, is the references to Deutsche Telekom and DSD, which are paragraphs 54 onwards.
So I'm sorry, to just go to the next page, please. Oh yeah, okay, yeah, it's that.
I'm not sure it's going to assist much further, but going back to page 2158, just the references to Deutsche Post, that was a case where the German postal service was charging the full internal Germany postal rate to packages which were being posted from Holland by people wishing to take advantage of Dutch international postal charges. And what the tribunal drew is at paragraph 56. 2 points notable: when it posted the mail in Holland to its German customers, there was no way the bank could avoid paying the postal charges demanded by Deutsche Post, and Deutsche Post were effectively double charging there.
That's de facto unavoidability.
De facto unavoidability. And in relation to DSD, that is from paragraph 57, that's discussed. And this was about fees for packaging. And again, what the tribunal drew from it is at paragraph 59 is that customers of DSD had no practical alternative to fixing the DGP logo to all their waste packaging, but they would get paid by those customers for collection of packaging which they didn't in fact collect at all. So again, it left the customers with no choice, so they're imposing unfair terms on them.
I mean, what you can say is that if on the facts, or if reading the CAT decision, the CAT judgment or the CMA decision, the evidence doesn't suggest there was this unavoidable trading failure, then you've got a serious question mark over whether there was imposition.
Exactly so.
Whether the law stretches to that, that may be a question.
Even if the court's not with me on the full breadth of my submission, in this case, can it be said once you knock out the assured customer base, or at least there's no finding in the tribunal's response to our challenge either way of the assured customer base? Once you can see that
about 50% of customers do switch.
Yeah. Then are you imposing a price on those who choose to remain? And we say no, we're not.
Whether you're in the...
Yeah.
Okay.
So that's that point. Then last 5 minutes today, there's the end of the abuse topic, which is the issue 3 on the court's list, which was concerned a related argument that we raised, which is that far from imposing prices, our prices were the product of a normal and sufficiently competitive process characterised by high levels of market entry and inexorable price reduction. And the short point is it didn't require a perfectly competitive outcome on day one of Intas's ownership. There was a process of workable competition. I think in that we covered a lot of this territory earlier on in our exchanges with members of the court at the outset of my submissions. I told you earlier that the CMA had accepted in their closing submissions to the tribunal that there was an effectively competitive market at that point. That is in their closing submissions at paragraph 310, which is at page 1239 of the reference supplementary bundle. And the point that we make about that is that the market structure, as I discussed earlier with my lords, had not changed. It was the same structure, it's the same level of market competition. And I think that takes us back to the submissions which I made at the earlier stage. This issue is also raised by my friends' submissions, and of course they say from their point of view that the writing was on the wall as early as 2015. Well, that's not part of my case, but for completeness, that's their submissions and their skeleton argument. And they say that same argument therefore runs back further. And there's reference in both our skeleton arguments to the case of NAP, which is in the authorities bundle at page 362, 390. Which is a reference to the Director of Fair Trading, in that case stating as a matter of principle the price is excessive, and the quote from director's decision at the top of page 363. It's above that which would exist in the competitive market, where it's clear that high profits will not stimulate successful new entry within a reasonable period. Therefore, to show that prices are excessive, it must be demonstrated that prices are higher than would be expected in a competitive market, and secondly, there is no effective competitive pressure to bring them down to competitive levels, nor is likely to be. At 391, that was accepted as being soundly based in the circumstances of that case. It was recognised that there might be other ways of approaching the issue in other circumstances, no doubt. Now, that authority only takes either of us a limited way, but it's the same nature of the inquiry we submit in this case, which is in the circumstances of this case, properly understood and approached, was there likely to be entry? And certainly from the start of the Intas period, well, there was, and it was likely that it would be increasing as there was over time. So we had that competitive market which reduced the prices relatively rapidly, ultimately to the level that they are
You
now.
have a set of facts which I think you have to rely upon, because if the price had been £1,000 and there had been entry, it had come down to 980. Because as in Sinven, I always find that using the tongue twister of describing the drug name. But in the Sinven case, it was accepted that there was some sort of, I think they called it sticky or gelatinous pricing once new entry came in, and there was a degree of oligopoly conscious parallelism. That prevented, at least for quite a long time, the price coming down to a competitive level. So it just to say new entry or likelihood of new entry doesn't necessarily get you very far. It doesn't tell you where the price is going to end up. Now, you can say here on the facts that it did come down from the height of the Matterhorn almost to ground level when it began to converge with the new entrance prices. So you're not stopping halfway down and putting down base camp and saying this is fine. you managed to get more or less to the bottom. Now, quite what how you analyse the period as you're coming down, you're still earning prices above the competitive level. What that means in terms of abuse is something we'll have to grapple with.
You need to grapple with, and
but you've got better facts than perhaps in
the tribunal. Yeah, but in this case, we said the tribunal didn't grapple with our submissions about this and the effect of the competitive market. Again, you've had lots of submissions already from my learned friend on the abuse, and I don't want to repeat any of that. It's sort of our fortiori in the Intas period.
Yeah.
Well, as I see the time, I'll break off that. I think I'll have to do my sums. I think I've got about 15 minutes left. Tomorrow, leaving 15 minutes for reply at the end of the case. I think I can refine and reduce what I was going to say on the economic value in light of the submissions that you've heard. There are some Intas-specific points. I'll make those as brief as I can, and then I'll be moving to penalty.
Maybe you can just tell us where we are in terms of submissions and so on.
Well,
We have been given a timetable somewhere.
we have. It's at the end of the reference bundles. It's the end of the reference bundles. I think the penultimate tab. So I'll give you a page number. No, that's the wrong bundle. Yes, it's 1984, the reference supplementary bundle.
It's not very illuminating, but I've got. Is that the one which just says they're still discussing? Has that been updated?
No, that was substitute.
Reference.
We did update that, admittedly comparatively recently.
I think it's too late. I mean, the problem is if it's updated that late, if I start marking things up, I can't start transferring things.
That is the version. Yes, that is the correct version that you have on the electronic at least. So that was the breakdown of issues amongst the appellants. So if we just drop down to the bottom of the page, you can see that the time allocations which have been agreed.
Go over the page, I think. Time allocation each by 4.5 hours.
So because my learned friends' submissions are split half and half
Yes.
between. I'm the
So
filling
you're
for the sandwich.
going to tomorrow deal with some penalties.
I'm going to deal with the penalties, and then my learned friends, between them, their submissions will follow on to complete the appellant's case within those overall
Mr. Johnson.
time.
Well, yes, I also have something to say as well. The entirety of our penalty appeals remain to be dealt with.
We gathered that.
Yes.
And you'll finish by...
I'm going to have to do the sums. So I think I've got 15 minutes, but I'll be corrected if I'm wrong.
Well, put it this way, when do you hand the baton to the CMA?
that I haven't done the sums on, but it would be presumably about lunchtime tomorrow would be or something on the ballpark. May I ask if we did ask, I know it was only 15 minutes, but if the court is prepared to...
Yes, well, we're conscious that people have applied to squeeze in an extra 15 minutes, so you get precisely...
Heavily negotiated.
Heavily negotiated. We can squeeze in bits and bobs here and there. We could start a little bit earlier tomorrow.
Yeah.
We could start at... I mean, I have a couple of pre-court meetings, but we should be able to start at, say, 10:15.
Thank you.
And then we may have a bit of time the following day to start early, so we may be able to grab a bit of time back. Shall we aim for a 10:15 tomorrow?
Thank you. I'm very grateful to the court. Thank you.
What